Earlier this year, Nigeria's National Information and Technology Development Agency issued the Nigeria Data Protection Regulation 2019. The regulation seeks, among other things, to safeguard the rights of persons to the privacy of their personal data by, among other things, other measures regulating transactions involving the collection, use, and exchange of personal data. Joining me now to look at the regulation and some of its imperatives for businesses that deal in the personal data of those that the regulation seeks to protect is the desk officer, Nigeria Data Protection Regulation, Femi Daniels. He joins us from our Abuja studio. Good morning, Mr. Daniel. Thank you for joining us.
Thank you very much.
All right, could you explain the new data privacy regulation of the federal government?
Thank you so much. The Nigeria Data Protection Regulation was issued in response to the emerging global trends in the use and transfer of private data. Nigeria had actually had pockets of efforts on data protection. We've had sectoral interventions from the CBN on customer data in the banking sector, the NCC on telco, then the health sector. However, the trend and the real thing going on in the world now is for you to have a converged national law that addresses issues of data transfer, collection, and use. The essence of this is that the fluidity of data, of personal data, is very much on the rise, and that's why we see that the likes of Facebook, Google, and some of the big tech companies are using data for so many other purposes outside of the primary ones we used to know. So the essence of the NDPR was NITDA's using its statutory mandates under Section 6C of the NITDA Act of 2007, to which mandates the agency to give framework and guidelines for electronic data interchange and electronic governance. The erstwhile Director General, who is now the Minister of Communications, ensured that we do something, a regulation that met global standards and also is locally relevant. So that, in a nutshell, is what the journey of the NDPR. And since the NDPR was issued on January 25th, 2019, there have been a lot of engagements. I mean, there have been both within and outside the country. Some have applauded, some have felt it was not sufficient. But overall, the aggregate consensus is that this is a right way to go. This is what we need to do while we are trying to still build upon the legal and other infrastructure that would make us to have a sustainable data protection ecosystem in the country.
All right, how is this similar to Europe's GDPR?
Yes, the GDPR is regarded as the gold standard in data protection regulation worldwide. America also has some sectoral laws on the health sector, banking, and all that. And then the state of California is trying to issue a consumer privacy law act, but which is still in the works. But the GDPR, taken from the experience that Europe has had over 3 decades of experience in data protection regulation, right from the early 1980s. They've had different iterations of data protection, and the various countries in Europe have had their own separate data protection regulation. However, the GDPR brought together the regime of data protection, and there are 7 major principles that the GDPR enunciates, which have also been covered under the NDPR. Some of those include that the data must be used for a specific purpose. You cannot, there must be consent, clear consent. Then the data privacy subject's right must be well enunciated and must be clearly communicated. And some 7 of those principles have all been covered under the NDPR. But beyond the fact that the NDPR sought to meet the global expectations on data protection, one of the things that the NDPR has also sought to do was to look at the Nigerian peculiar environment, and we try to distill what we need, not necessarily what the Europeans, what they have provided. For example, you look at the preamble to the GDPR, for example, is about 55 paragraph, 120 paragraphs, over 55 pages. That, of course, was not going to be applicable to Nigeria. And there are some provisions in the GDPR which more or less is a surplusage for the Nigerian environment. So looking at our journey, the fact that we have not gone too far, and we don't have too much history on data protection, what we have done was to localize the regulation while still meeting up with the requisite standards and principles which have all been properly captured under the NDPR. That is how, the relationship between the NDPR and the GDPR.
Now, what category of organizations is affected by this new regulation?
Yes, the NDPR, because the NDPR emanates from the NITDA Act, which the NITDA Act gives the NITDA the power to regulate IT. There are three critical functions of NITDA. Number one is to regulate information technology systems activities to develop information technology, particularly for the underserved areas, and also to advise government on issues relating to IT and the digital environment. The NITDA Act covers both public and private sector, and every other person that are connected therewith. But particularly talking about the NDPR applies to Nigerians living in Nigeria and outside of Nigeria, and everybody who is living within Nigeria. So if you're a foreigner who is living in Nigeria, you also have the protection of the NDPR. If your data rights have been breached as a foreigner in Nigeria, you are also protected.
So what sort of impact do you think this new law will bring about, not just in the technology industry, but the business climate in Nigeria?
Yes, the impact is enormous. Before the NDPR was issued, one of the things that was going on is that Nigeria was becoming a pariah state in terms of business environment. Immediately the GDPR came into effect on 25th of May 2018. All the contractors and consultants that could supply or provide services to European related organizations in Nigeria, they could not recruit Nigerians. That implied that even the sweeper for embassies that are of European origin could not they cannot get Nigerians. That is taking a lot of money out of Nigeria and disempowering Nigerians. What the NDPR has sought to do is, number one, to provide a regulation that meets the basic global standards, and also to give us a basis of engaging, the foreign investors and partners to ensure that Nigerians, while not necessarily complying with the fine details of the GDPR, but they can comply with the NDPR and still protect the data of foreigners and Nigerians alike. So number one, it has opened up the opportunity space for Nigerian businesses, and also it has given us a room to further engage with foreigners and other countries to effectively be able to have a conversation about deepening what we already have. It's a journey that has started. It's not yet a destination, but we are happy and glad that it has begun and it is moving in the right direction.
All right, now, many experts have argued that NITDA has no right to make such far-reaching policies. Is NITDA backed by any law? Does it have the capacity now to function effectively?
Thank you very much. It's a very important question, because any action taken by a government agency must be rooted on a particular act of the National Assembly. Before I talk about the NITDA Act, there was an IT policy, which is still the one that is the current one, of 2000, National Information Technology Policy of 2000. Strategy 13.33 of that document indicated that there should be a a mechanism for protection of privacy rights, and that government should do whatsoever needs to be done by creating necessary agencies and infrastructure to ensure that those rights are protected. The same IT policy indicated that NITDA, National Information Technology Development Agency, should be established. And NITDA was established in 2001, but the NITDA Act was passed in 2007. The NITDA Act in Section 6 particularly gives a very wide mandate to NITDA. Section 6A, for example, talks about the NITDA's power to regulate everything relating to information technology systems, activities, and processes. What that implies is that everything relating to IT, that whether input or output of IT, is under the purview of NITDA as a regulator. And what makes it more pertinent is also that IT is no longer just a sector. It is an enabler for every sector, and that is why there are some kinds of challenges, because people feel that there are sectors and they should not be regulated by NITDA. But the idea is not unnecessarily to stifle or to grab power unnecessarily. That is not the idea of the NDPR. The NDPR was created to give every sector a chance for us to start a conversation towards deepening our data privacy regime. Whatsoever the different sectors had could still be improved on. I mean, the NDPR forms a basis for further engagement, and we are glad that those conversations have started with the Security and Exchange Commission. It's beginning with the banking sector and some other sectors. These are the kinds of things that brings an autochthonous model of developing regulation. So to answer your question, yes, NITDA is well empowered by the NITDA Act of 2007. Aside from the Section 6A that I mentioned, also Section 6C provides clearly that NITDA is mandated to provide framework for electronic data interchange and electronic governance. There is no other law as of today in Nigeria that gives this explicit, uncontestable power on data regulation in Nigeria.
All right, so how does this data protection law relate to the capital market?
Yes, the capital market is a huge data processor and data user. There are some of the data that is being processed by the capital market that do not necessarily fall under the classification of personally identifiable information. Even there are some other information that are in the capital market, which, even though they are personally identifiable information, however, they are statutory information that needs to be in the public domain. So, for example, the information of directors of companies, and some other corporate governance expectations that have been laid down, those you do not have rights to protect them, so long as they are being used for the purpose for which they were originally collected. However, the NDPR now gives a clearer dimension to reduce the abuse of personal data even in public domain. So if the capital market operators have collected personal information, what they can use those information for is only for the furtherance of the purpose for which they were originally collected. And those purposes are actually stated in the various acts, the Investment and Securities Act and the extant laws relating to the Securities and Exchange Commission. However, when you now use those information outside of those regulated areas, it becomes a breach, which can actually lead to civil liability, criminal prosecution, or administrative fines, which are all embedded within the NDPR framework.
All right, Mr. Daniel, there was a case of an alleged unlawful disclosure of the personal data of a Nigerian citizen by officials of the Nigerian Immigration Service. Now, the man allegedly destroyed 5 diplomatic cars in front of Nigeria High Commission in London after the collection of his Nigerian passport was delayed, even after the payment of all the required fees. Now, a lot of people argued that the development contravened provisions of the Nigeria Data Protection Regulation. What's your take on this?
One of the first enforcement actions that the NITDA took upon the issuance of the NDPR was actually to call out the Nigeria Immigration Service, not unnecessarily to file charges, which is it's an option on the table. The erstwhile Director General issued a letter to the Comptroller General of Immigration, Nigeria Immigration Service, which the letter was delivered, and we have invited them for them to explain the circumstances around that occurrence. And of course, those conversations are going on. However, one thing about data protection enforcement is that it's not something that happens and within 1 week or 1 day. The various fines regime that have been imposed on the European, from Europe and other parts of the world, for example, the Marriott case investigation started as far back as 2016. And we also have so many others that you do not take nothing less than 1 year or more to be able to establish culpability of whoever is involved. That does not mean that Nigeria cannot be different, but by taking the necessary first action to invite the Nigeria Immigration Service for them to make necessary explanations, it gives an indication that NITDA is willing, able, and ready to actually ensure that this regulation is enforced. And that is just one out of so many other enforcement actions that have been taken, which we are not comfortable for now to put in the public domain. However, there are a lot of efforts, going on behind the scene. We want to be able to announce some of these fines and punitive measures when the processes are concluded, because while data protection is a right, privacy right is sacrosanct under Section 37 of the Constitution. Nevertheless, that right is also subject to the right of fair hearing and justice. So we are trying to ensure that there is a balance between the personal rights of the person in UK whose passport was exposed, and also the structure of our constitution to ensure that both sides have fair hearing.
Now, you just have less than 30 seconds to answer this question. Should there be a litigation, how will the courts handle the situation since the regulation is not backed by an act of parliament?
The regulation is backed by an act of the parliament, which is NITDA Act 2007, and there had been a judicial case that had given judicial imprimatur on the Nigerian Data Protection Regulation. That is the case of Nigeria Paradigm Initiative versus NIMSI, where the court considered and established that the NDPR is a veritable instrument to protect the collection and use and storage of personal data in Nigeria.
All right, thank you, Mr. Daniel, for your time. I've been talking to Femi Daniel. He's the desk officer at Nigeria Data Protection Regulation.